changes to the Consumer Product Safety Improvement Act, a bill that was passed in honor of the many children who have been injured or killed by dangerous products, including Danny Kaiser. Danny was just 16 months old when he was strangled in a portable crib that collapsed. When Danny was killed, the crib model had been recalled for 5 years already and had caused the deaths of 4 other children. Danny died on May 12, 1998, exactly 13 years ago today. And here we are honoring his memory by considering legislation that would roll back the protections in landmark legislation that bears his name. Madam Chairwoman, I understand that the current draft of this legislation restores third-party testing for durable infant products, including cribs, so that we can prevent deaths like Danny. I appreciate your efforts to protect these provisions, which I authored and which were named in Danny's honor. Durable infant goods are the items that get used over a period of years, often for multiple children, and may get passed around among family, friends, and neighbors. Ensuring that such products are safe is absolutely critical. Parents should feel confident that the cribs, bassinets, and playpens they use, where young children sleep and are left alone for significant periods of time, are safe. However, while this bill protects third-party testing for those items, at the same time it dramatically undermines third-party testing for countless other children's products. This bill would place so many burdens on the CPSC that mandating third-party testing for lead, phthalates, and the toy safety standard would be nearly impossible. It would take us back to the situation we were in before we passed the CPSIA, to the days when our children were the test subjects for safety. The CPSIA was drafted, negotiated, and passed with strong bipartisan support at every step of the process. We all acknowledge that there are some technical fixes, as Mr. Waxman has outlined and had offered over the last couple years, and that would allow the CPSC to better implement the bill. This subcommittee should be able to come to an agreement on a bipartisan basis to make those fixes. Unfortunately, the bill before us today does not represent the type of collaboration and agreement, and I can't support it as written. I certainly remember the early negotiations with Mr. Barton, back and forth on practically every paragraph. It was a great effort working together. I think we can do that again to improve this legislation. We're all in agreement that it could use improvement, but I think the manner in which the committee has operated now does not lend itself to that kind of compromise. And finally, let me say, when we talk about constituents, I hope we're not just talking about industry. We are talking about the many consumers and children that are out there that need our advocacy. I yield back.